On a matter of privilege, the chair the member for Fox Hill had requested an opportunity to respond because this member was named, in particular in an injunction that the court saw fit to impose on the Parliament, and the chair has certainly complied and would wish the member at this time, if the member so oblige, as per our discussion, to rise on a matter of privilege. Chair recognizes the honourable member for Fox Hill.
Yeah, thank you, Mr. Speaker, but I would like, before getting into that, to simply pass on my condolences on the passing of Mrs. Cleveland Eneas. Many of us know her as Finny. Affectionately, she used to be the principal of St. Anne's High School. She is the mother of Dr. Judson and Dr. Fritzie Eneas and Dr. Greta Eneas, and a well-known lady in her own right. She certainly stood with her husband in all of his civic endeavors, but certainly developed for herself her own reputation as an educator and a shaper of the modern Bahamas. She passed yesterday. She was in her 90s, I believe, so she lived a very long and productive life. And I want to join on behalf of my family and constituents in expressing condolences on her passing. And I just wanted to start at that point. I rise, Mr. Speaker, as you said, on this point of privilege. You will recall that when the House of Assembly met over the last few weeks, on each occasion I was out of the country on official business. I had the opportunity to speak to you over the telephone, giving you my clear and unqualified response to a purported injunction given ex parte by a judge of the Supreme Court, which was seeking to prevent two members of Parliament from carrying out their constitutional functions in this House and in this country. I now rise to speak on a matter of privilege at this first convenient point. I've had the advantage of the benefit of your views, and I've read the texts of those statements made by you as Speaker with regard to the purported action of the judge of the Supreme Court. I had thought this matter would have been properly put behind us by a dismissal in the courts by now of what is, in my view, a totally misconceived action on the part of some pretty desperate people to stifle free speech and debate, sourced from the very group that is calling for freedom of information. Sadly, it is not behind us, and counsel has had to be retained in order to deal with this matter in the courts. My own view is quite clear again. The action is misconceived, foolish, and the decision is manifestly wrong in law. The privilege which I have to speak in this House is an unqualified privilege, not qualified in any way, save for any limitations which the Parliament itself imposes. And I wish for the general public to read into the record the law on this matter. I start with the Constitution. Article 53(1) reads, "Without prejudice to the generality of Article 52(1) of this Constitution, and subject to the provisions of paragraph 2 of this article, Parliament may by law determine the privileges, immunities, and powers of the Senate and the House of Assembly and the members thereof." So, Mr. Speaker, Parliament, in this Constitution, Parliament may by law determine the privileges, immunities, and powers of the Senate and the House of Assembly and the members thereof. And it goes on to say, no process issued by any court in the exercise of its civil jurisdiction shall be served or executed within the precincts of the Senate or the House of Assembly while it is sitting, or through the President or the Speaker, the Clerk, or any other officer of either House. And that's the end of that subsection. Now, the Parliament then went and passed a law, Section 3 of the Powers and Privileges Act, which was passed pursuant to this article of the Constitution, which says, Mr. Speaker, again, that Parliament can determine the extent of the immunities, privileges, and powers. And I would argue that Parliament can be as expansive as it wishes. And here's what it says. Senators and members shall have the like privileges and immunities as are enjoyed for the time being in the United Kingdom by members of the House of Commons of Parliament, and without derogation from the generality of the privileges and immunities conferred by this section in particular, shall have such privileges and immunities as are provided hereinafter in this Act. And then it says, no civil or criminal proceedings may be instituted against any senator or member for words spoken before or written in a report to the Senate or the House respectively, or a committee, or by reason of any matter or thing so brought by him by petition, bill, motion, or otherwise. So anything said or spoken, words spoken or said or written in a report to the Senate or the House has an absolute protection in the law. There's no doubt about what those words mean. So the question is, what is there for a court to consider in this matter? I've had the advantage of conferring with and reading the statement of the Member of Parliament for Marathon, my honorable friend. And I wish to quote from his statement delivered in this chamber on the 22nd of April. And, and he said, on the 22nd of April, he delivered this in May, but he said, on the 22nd of April, I and the Member of Parliament for Fox Hill issued the following statement. I repeat, first of all, what I said in our statement, that no one can deter this member when it comes to speaking freely on behalf of my constituents or when my privilege has been assaulted. I have the privilege of freedom of speech generally, and specifically there is immunity which attaches both on the criminal and civil side for anything which I or any member says in here. Any injunction, then, which purports to restrict that seeks to do so in vain. It is a well-known axiom of law that equity does not act in vain. What it says, Mr. Speaker, is, even if we broke the injunction, what was the court going to do? How are they going to enforce it? That's what we mean by equity acting in vain. It is unenforceable. Injunctions are an equitable remedy, and thus I cannot see how an injunction could have been granted since it is so obviously contrary to law. And he says, put another way, given the Constitution and the law, if we speak in here as we will, how is their remedy to be enforced? The judge by this order has set up a conflict between the two branches of government, the legislature and the courts. Under these circumstances, it is clear who will lose. One only needs to read carefully Article 53(2), which I've done, of the Constitution, and then go to the Powers and Privileges Act to see we are absolutely supported by the law in here. The matter was first laid before the Committee on Privileges by resolution on the 21st of March, 2016. Thus, the false accusation made by the representatives of Save the Bays and Mr. Louis Bacon against me personally that I or ministers of the government got unauthorized access to emails of Save the Bays is now before the Committee of Privileges, and I expect the committee to call all those who made such outrageous accusations of criminal behavior against me and other members to come and produce what evidence they have to support their libelous and defamatory claims. Mr. Speaker, he continued, I am now putting before the House for further consideration the purported injunction, and I am suggesting to this House that the common law powers of contempt and the statutory powers of contempt can lead to the lawyers Fred Smith and Ferran Bethel to be brought before the Committee of Privileges to determine whether this House should consider that they are in fact in contempt of Parliament. I use as support the documents I have tabled. And then he says, these people are getting desperate to hide their scandalous activities and schemes from the public, and in their desperation they have fallen into grave error. I've had enough, and I mean it. I close, he says, quoting from the 22nd edition of May's on parliamentary practice, subject to the rules of order in debate, a member may state whatever he thinks fit in debate, however offensive it may be to the feelings or injurious to the character of individuals, as he is protected by his privilege from any action for libel, as well as from any questions or molestation. Final legal recognition of the privilege of freedom of speech in both houses of Parliament is to be found in Article 9 of the Bill of Rights in 1689, which states, and he quotes, "The freedom of speech and debate or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament." That's the law of the Bahamas. Now, Mr. Speaker, that's the end of the quote. I want to adopt these words as if they were my own. And I go further. I want to make this clear. I do not consider myself bound by any injunction issued by any court insofar as it applies to any attempt to stifle what I say and do in this place. I will simply act accordingly. And I want to say that those who, for political convenience, now find this uncomfortable cannot have their cake and eat it too. You cannot approbate and reprobate at the same time. The reasons for the privilege are manifold, but I say this. Those who argued that it was fine to steal the banking records of customers of the Bank of the Bahamas and thought that there was nothing wrong with that because they believed by exposing the private banking affairs of public figures they were serving a public good, have no legs to stand on in this argument. And you remember it, records of the Bank of the Bahamas, stolen and produced and printed in the newspaper. Nobody seemed to have any care about people's privacy in that case. None. Said the same crew. Those who publish stolen cabinet papers because they believe that it serves a greater good, they too have no leg to stand on in this argument. I assure the public that these documents which are before this House are not purloined or stolen or unauthorized, as the progenitors of this foolish court action have sought to say. I ask the public to consider this. When the facts reveal, Mr. Speaker, the facts reveal that there is in fact, or was in fact, a conspiracy to destabilize the government, funded by high net worth individuals, surely by the same reasoning that you argue it was fine to publish stolen material, publishing this material obviously meets the test of a public good. There's no question about that. The elements are all there. The evidence is there. You have a Queen's Counsel who's been hired time and time again by the same set of moneyed foreign interests. He himself has on a number of occasions urged people to sue the government, to bankrupt the government, out of his own mouth. He is pledged to run in the Fox Hill constituency, funded by who knows what and to what end. He now has several legal actions, Mr. Speaker, against this member of Parliament in the courts against me. He says, in my personal capacity, so the end point is if he succeeds with this, is to bankrupt me personally. So this is war. This is war. This is again funded, and I ask the question, funded by whom and for what reason? Why? Mr. Speaker, I don't take this lightly, and will fight this with all my being. I've worked too hard to get to this high court of Parliament where there is a complete immunity for what I say and do in this place. I reminded people in history an English king lost his head for fooling with Parliament over this issue. The action before the courts is a nonsense, and I hope the courts will see their way clear to deal with it appropriately. In the meantime, I can assure my constituents that I will not blink or stutter and continue to serve unswervingly their interest in this place. And I wish now to lay my remarks over for further consideration of the Committee on Privileges. Thank you, Mr. Speaker.